H. Smith. The last procedural matter on it is prior to this hearing, counsel for the represented parties stipulated that the board could have various exhibits. Generally, the Water Management Board has exhibits that they receive from the water program that provides them a general background of the pleadings that were filed. And as such on it, I just briefly would like to go through what the board has received prior to this date on it. And that the board has received all of the petitions in support and opposition to the applications that were received, except for these last page numbers on it. We received a copy of the notice of hearing and that was published, and received the report from the Water Rights Program, which was 2 expert reports with exhibits regarding the staff's position on this matter, as well as the recommendation of the chief engineer as to the position of staff regarding this permit. The 2 permits. We also received from applicant an expert report, investigation of Lake Ponset water quality and quantity concerns from Patrick Emmons and Susan Berkman. And finally, what the board received was pre-hearing summaries and details from 2 Department of Game and Fish and Parks witnesses, Leslie Peterson and Mark Eamer on it. And all these materials were provided to the board beforehand. The board had an opportunity to review them on it. And they are now part of the record, and that they would not need to be reintroduced. Anything that has been received up to now would be part of the record to be relied upon, unless you want to make it as an exhibit, separate exhibit.
Jeff, is that also true of the CVs?
The CVs were already received on it to the extent that they were received on it as per stipulation on it. Now, if the parties object to that, it would still be a matter of the CVs were introduced. Not the determination of whether they were next year. We still have to lay down whatever would be needed unless the parties are going to stipulate.
I would also ask the question, what is the date of the investigation of Lake Ponset that you received? I know that the board has received the most up-to-date, I just want to make sure.
Well, let me go through them specifically on it. What was is that we received the updated flood control application of September 1st, 2009. And we received the updated flood control application, FC 5A, and water permit application number 7088-3, Lake Ponset Water Project, September 1st, 2009. It was prepared by Lynn Beck. Received the Lake Ponset Water Quality Investigative Report, January 2009. That was prepared by Paul Lorenzen with exhibits. Received the supplemental report from Mr. Lorenzen dated September 2009 on the Lake Ponset. It's called Lake Ponset Supplemental Water Quality Investigative Report. Those are the reports that were received, and I believe I previously indicated that of the 2 Eater witnesses in summary of testimony.
Actually, the one I was specifically asking about was the investigation of the applicants. It just has the date on it.
Okay, applicants would be June 29, 2009. That's the and that's the one that we received and
Yes, sir.
And if I may clear up what's been provided to the board as well. And as the board recalls, this matter was originally set for hearing the first week in July, and due to an illness, it got continued until now. Pursuant to stipulation, the CCNR has sent out a Lynn Beck report, and she updated that now, and this one's called updated Lynn Beck report. So you actually have received the original report before, and then the updated report. And the updated report is the one she'll be testifying on today, but I want to make it clear that there has been two different things provided.
And the original report was May 7th, 2009?
Correct, yes.
Okay.
Yes.
Okay, that was also received on.
And we have marked those, or marked Lynn Beck's revised report as 3A, and we'll be having her testifying off of it with that number on it.
Now, for procedural purposes on it, unless, counsel for the parties have any objections, I'd like to have the opening statements begin with from the applicant, next with the department and with all interveners. And then for the presentation of the case on it, have counsel agreed on how they want to present this matter?
Yeah.
So, and then for the ability for questioning on it, as you said, cross-examination, do you have any order that you would choose to go through?
Yes, the DENR would proceed first, and then Kingsbridge.
And then Mr. Smith would have the last opportunity to ask questions. So, do any of the parties have any objection to that procedure? Then what we'll do is redirect, recross, and then we'll be open to the board for questions. After the board's asked their questions, the parties have the ability to follow up, limited to what the board has. Mr. Freeman is an experienced lawyer. He'll be making rulings on any objections. If there's any questions that he may have, he may ask me on it, but he'll be handling the actual procedure with the hearing on it. Will be, unless something's already part of the record, or unless the parties have stipulated the standard foundation on the exhibits. Hopefully there's copies for all of counsel, Mr. Smith, any of the other, and as well as the board itself. We'd ask, any of the people that are out here, if they want to testify, let one of the parties know. We're trying to prevent repetitious testimony, but if there's things that the board, people determine that the board should hear, either Mr. Smith or one of the parties on it, ask them on it. Otherwise, we just ask people to be quiet. And Mr. Smith, you have the opportunity to testify, but otherwise you're going to be acting as a lawyer, so you can sure question the parties, but that is not the time for you to testify. So you can ask any questions you would like to have to develop the record, but your ability to testify would be as part of your case on it. So you would have the ability to testify after Mr. Neal has presented any evidence that he has on behalf of the Cambridge Party. Does anybody have any questions? I think we got all the preliminary matters taken care of.
The witnesses will be located.
The witnesses will be up there. That way the court reporter will swear them in. They'll be up there, and then counsel would be here unless there's going to be some issues on it. And
we had discussed about having the witnesses located next to the court reporter for a couple of reasons. Number one, court reporter to hear possibly better. Number two, most of the witnesses will be referring to exhibits.
okay, that'd be fine on it. We have a chair or something then for move the podium over. I think.
Do you want the podium moved, Jeff?
For opening statements, could you use the podium?
Well, how about, this is going to be difficult, but probably counsel can go up there for opening statements. If we have the witness over there, will that work for you? And then we're going to ask counsel and all the parties to make sure that they're loud enough. I know my problem is sometimes I'm not loud enough. So that to speak loud enough not only for the court, but also for all the people that are here today.
And if somebody in the back can't hear, just wave your arm, let us know, and we'll remind the witness to speak up.
Also, there are a couple of places up here closer if you want to move up closer so you can hear. Any other preliminary matters?
Mr. Hallam, I would ask one now. We're down to 5 members of the board. Do we abide by the quorum for a vote, or is it a simple majority of those present? Pass. I always